being worried about. They're in a routine stuff.
It's going to see myself. I don't even need to be there.
I was going to say,
I just gotta pick them up, drop
I
off.
knew you were good.
You have both?
No, no.
Hey, so where's Crystal? Right, exactly. Did she bring the story? It was this one. Thank you. I appreciate it. When you're talking about my high thing, you are arguing something that is not in evidence.
That's an argument I used to all the time.
That's me.
I think that my space is required. I'll probably have to stay though overall, I would imagine.
All rise, please. Circuit Court is back in session.
Is the smoker back?
Sorry?
Is the smoker back? You don't know.
I'll find out.
The smoker.
Birch Deloitte. Are you ready to go? Half a minute, he said.
Okay.
Are you ready to bring him in?
Yes, ma'am.
Birch Deloitte, when you can bring him in.
Yeah, my eyes are like throbbing. It's always my fault.
Okay. The jurors are present, seated in jury box.
Deputy Birch, you want to come over here a second? Ms. Olney, you may give your closing at this time.
Thank you, Your Honor.
Defense counsel wants you to believe that the state thinks Jennifer Mee masterminded this whole entire event. I submit to you, ladies and gentlemen, that Jennifer Mee participated, and she participated in this fashion. She was the bait. She was the bait that lured Shannon Griffin to a back alley that was dark where two of her cohorts waited. Two of her cohorts waited in the dark. She was the bait that attracted him there. He was excited. He was looking forward to seeing a young lady. She was the young lady. And that is why Shannon Griffin is not with us any longer. Isn't it too bad that he's not here to tell us exactly what occurred that night, the night of October 23rd, 2010? Was he there to buy marijuana? Was he there because she lured him there? The only evidence about marijuana comes from the defendant, Jennifer Mee. Nice clothes, cologne, excited, lured there by Jennifer Mee. And how do we know that? How do we know that, ladies and gentlemen? Mr. Trevina, in his opening statement, told you that our star witness was Jennifer Sharon. We didn't even call Jennifer Sharon. You know who our star witness is? The defendant, Jennifer Mee. She's our star witness. I called the victim. I met him on Moco Space 4 or 5 days ago. It was my idea to contact him and get the money. I used LaRon's phone to text him, and he appeared to meet me. He said he was going to buy half ounce of weed for $55. But we didn't have no weed to sell him. We wanted his money. Last night, I spoke to the victim. He wrote me on Moco Space, talking about wanted some weed. Detective DeLuca asked him, and what were the intentions when you gave him LaRon's phone number? Were your intentions to sell him some weed? No, sir. The intentions of both boys was just to rob him, and that was it. Was she a principal in a robbery? You bet. And why do we reiterate the principle over and over? Because it's important for you to know and understand. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Jennifer Mee took the money or property from the person or custody of Shannon Griffin. Then we go to the principal statute. If Jennifer Mee helped another person or persons commit or attempt to commit a crime, Jennifer Mee is a principal and must be treated as if she had done all the things the other person or persons did, if she had a conscious intent that the robbery be done. The robbery, taking of money or property, the bait, the lure to get that young man back in a dark alley where he could be robbed and his money taken. That Jennifer Mee did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons who actually committed or attempted to commit the crime. The phone call, ladies and gentlemen, that was thought out prior to that young man arriving there. That phone call, that exchange between the two of them, that was her act. Sending him back down the dark alley was her second act. That force, violence, assault, or putting in fear was used in the course of the taking. I suggest to you, ladies and gentlemen, there was a struggle to get his property. And the struggle didn't work, so they pulled out a firearm and they killed Shannon Griffin so they could go through his pockets and take his property. And you read the principal statute with every element of the robbery. You read that principal statute because it goes to every element of the robbery. If those boys did it, she did it. Let's talk a little bit about Detective Warzinski and the St. Petersburg Police Department. Apparently, defense counsel would like you to believe that they did a horrible job at an investigation. I submit to you, ladies and gentlemen, they started at about 10 p.m. on October 23rd, went through the night, through the next day, making every effort to contact LaRon Rayford every effort, because that's the only name they had. And that was because they got the phone records of Shannon Griffin and were able to connect that he had had contact with LaRon Rayford's phone. They didn't know yet that this young lady, Jennifer Mee, the bait, was using his phone. So their whole focus at that point is on LaRon Rayford. And they're doing everything they can to find him. They know he has an associate, Jennifer Sharon. They figure out that they're living together. They're trying to contact her. She's a no help. She's trying to help him get away. She doesn't answer her phone, and if she does, she hangs it up. But they get information that he's at an apartment off 89th Avenue, North St. Pete. And they go there. So now, we start at 10, 11 p.m. on Saturday night. Now we are Sunday, and it's approximately 3 p.m., and they're still working it. They're still working it, ladies and gentlemen. They go there. They see Jennifer Mee with Jennifer Sharon. They know who Sharon is because they pulled her picture up. They pull him over. They tried to get Sharon to say, "Where's LaRon Rayford?" She won't tell them. She's not going to talk. They take her down to the police department, and Jennifer Mee goes as well. At some point, shortly after they arrive at the police department, she sees LaRon Rayford. She now knows he's under arrest. Gary Gibson, Detective Gibson, goes in and talks with her. She gives him a statement. I ask you, ladies and gentlemen, to totally disregard that statement because it's untrue. And why is it untrue? It doesn't go with her statement. And her statement, ladies and gentlemen, if you are innocent of a crime, why would you tell two different people that you committed the crime? Detective Warzinski, she told. She talked to him freely for about 10 minutes. Then he offered to tape her statement, and you have it in evidence. You can listen to the tape statement where she admits to luring him there. She admits to partaking in this robbery. But who else did she tell, ladies and gentlemen? Her mother. Her mother. I set everything up. It all went wrong. She's crying. She's emotional. It went wrong. You bet it went wrong. It went wrong for Shannon Griffin. That's who it went wrong for. Defense counsel would have you believe, and I'm asking you to rely on your own memories as to what took place. But I submit to you, he asked the detective if he could have ruled out the first version. And the detective said he couldn't. But we got back up on redirect, and I ask you to recall this. He was referring to the initial part of the investigation. Would he have been able to rule that out before he knew what had occurred? And no, he wouldn't have. And he said, but that now, after the investigation was completed, was inconsistent with everything else. So that's not quite factually accurate. And the defense counsel is throwing up a cloud. I'm asking you, ladies and gentlemen, to use your common sense. Use your common sense with the facts in this case. We've got a T-shirt with the defendant's DNA on it. a T-shirt, by the way, a tank top, that's found in the book bag where the gun is kept. It's not just a tank top that's lying around the house. It's with the gun. We have a fingerprint on a driver's license that belonged to Shannon Griffin. What can be said about that? What can be said is that she had that driver's license in her hands. That was property taken from Shannon Griffin. And that alone, ladies and gentlemen, we don't have to prove that they took $55. We don't know if Shannon Griffin took $55 there with him because he's not here to tell us. We do not have to prove that they took $55. We don't have to prove that they took $1. What we know they took was his wallet that included his driver's license and his phone. Those are the things we know they took because those are the things that were hidden up in a vent in someone's apartment. And why were they hidden there? So the police would never know what occurred. The only witnesses we have to this crime, ladies and gentlemen, are Jennifer Mee, the defendant, these are the three witnesses that we have in this crime. The defendant, Jennifer Mee, the defendant, Lamont Newton, and the defendant, LaRon Rayford. There are no other witnesses. We have a neighbor who reported hearing gunshots, testified that he heard gunshots, thought it was close by, went out and looked to see if it was at his house. Something fell. It was a loud clang. He walked down the street and he thought he saw a white male who was elderly. I submit to you, ladies and gentlemen, that is how dark it was back in that corner where Shannon Griffin lay dying. That's how dark it was. DNA evidence on the T-shirt, the tank top, DNA evidence of one of Miss Mee's cohorts on a number of items to include the firearm. Defense counsel talked about secondary transfer a little bit, how if he touched here, he just thought it was amazing that Mr. Labruzzo could come over here and touch it and then put Mr. Trevina's DNA somewhere. But I want you to recall the testimony of that witness. And she said, Ms. Borys, secondary transfers are highly unlikely to result in DNA. What does that tell you? It tells you that LaRon Rayford probably had a hold of that gun and used it to shoot and kill Shannon Griffin. but only after Jennifer Mee called Shannon Griffin and invited him to this crime scene. Had that never happened, he would never have been robbed at gunpoint by Lamont Newton and LaRon Rayford. Dr. Wilson testified that there wouldn't be any soot around the wounds, if you'll recall. And that's important because it shows how close the shooter would have been to Shannon Griffin. The problem with that is, and we won't know and we don't know, is that Shannon Griffin had 2 shirts on. Look at the pictures, ladies and gentlemen. He had 2 shirts on, which would prevent any soot from getting around that wound. So I submit to you that we don't know how close the guns were fired. The gun was fired. And by the way, I want you to look at those photos also. Those shoes that Shannon Griffin was wearing weren't untied. You look at the photographs and you'll see that the shoes were tied. But what about the shoes? What is the importance of the fact that the defendants didn't take his shoes? They left their shoes there also. Why? They had to get out of there. They left the gun there, they left their hat there, they left the book bag there. You think they're going to stop and pick up Shannon's shoes? That makes no sense. Use your common sense. It means nothing. There is no value to the fact that his shoes were left there and they didn't take them with them. That doesn't mean defense counsel would have you believe because they didn't take the shoes, they didn't take any property. Well, we know that's not true because the property was found in another location where all 3 defendants were found. The statements that Detective Warzinski took from Jennifer Mee. He's criticized for not knowing Detective Gibson had spoken to him. But as he tried to relay to you what the St. Petersburg Police Department was like, or is like, and especially like that night, you heard that there were a number of detectives there. There were uniformed officers there, all in this area. There were witnesses that were showing up downstairs that Detective Gibson told you he had to leave and go down and talk to people that had come up to the front desk. Suffice it to say that there was a lot going on. And yes, they were trying to solve this crime. They'd been on it for 24 hours, practically. And remember, Detective Warzinski had just spoken to LaRon Rayford, and whatever he learned from LaRon Rayford set him on Jennifer Mee. Tell the truth. You got to tell the truth. I submit to you, ladies and gentlemen, that the truth comes from our main witness, Jennifer Mee. Listen to those tapes, please. I invite you to listen to them over and over again. And while I'm on that subject, the tape statement that was given to, there's 2 tapes on there. You have to get both statements, you have to listen to the entirety of the tape. They're all on one tape, is what I mean to say. So you're not going to have a tape that you take in and out. So you have to listen to the entirety on the one CD that you'll have to take back there with you. But again, mastermind? No. Bait? Yes. When you go back to deliberate, the judge is going to tell you, one of the laws, if you return a verdict of guilty, it should be for the highest crime which has been proven beyond a reasonable doubt. So you start with first-degree murder, felony murder, ladies and gentlemen. Listen to the law that the judge gives you. You'll have it to review. I submit to you that the state has proven that Jennifer Mee is guilty of felony murder, first-degree murder, and that you don't have to go any further. There are lesser included offenses, but you wouldn't go down to those lesser included offenses unless you felt that we had not met that burden. Because you are to return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. We talked about sympathy. The courtroom is not a place for sympathy. I ask you all, ladies and gentlemen, to use your common sense. Use your common sense and return a verdict that is consistent with the evidence that you have had before you in this case. Consistent with the evidence that Jennifer Mee lured Shannon Griffin to his death when she helped LaRon Rayford and Lamont Newton set up a robbery. I ask you to find her guilty as charged of these crimes. Thank you.
Okay, the deputy's going to hand out the jury instructions. You'll each get a packet when you do. If you just look up at me, then you can read along silently while I read them aloud. Okay, everybody got it? All right. Open up the packet. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Jennifer Mee, the defendant in this case, has been accused of the crime of murder in the first degree. In this case, Jennifer Mee is accused of murder in the first degree. Murder in the first degree includes the lesser crime of manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Shannon Griffin was killed by Jennifer Mee, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the first degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Jennifer Mee may be found guilty of murder in the first degree or any lesser included crimes. Felony murder, first degree. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, Shannon Griffin is dead. 2, the death occurred as a consequence of and while Jennifer Mee was engaged in or attempting the commission of a robbery. 3, Shannon Griffin was killed by a person other than Jennifer Mee, but both Jennifer Mee and the person who killed Shannon Griffin were principals in the commission of robbery. In order to convict a first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. I will now define for you the crime of robbery. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. 1, Jennifer Mee took the money or property from the person or custody of Shannon Griffin. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Shannon Griffin of his right to the property or any benefit from it. And the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. The taking must be by the use of force or violence or by assault so as to overcome the resistance of the victim, or by putting the victim in fear so that the victim does not resist. The law does not require that the victim of robbery resist to any particular extent, or that the victim offer any actual physical resistance if the circumstances are such that the victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of the victim. It is sufficient if the property taken is under the actual control of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. I will now define for you attempt to commit a crime. In order to prove that the defendant attempted to commit the crime of robbery, the state must prove the following beyond a reasonable doubt. 1, Jennifer Mee did some act toward committing the crime of robbery that went beyond just thinking or talking about it. 2, she would have committed the crime except that someone prevented her from committing the crime of robbery or she failed. It is not an attempt to commit robbery if the defendant abandoned her attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of a criminal purpose. I will now define for you principles. If Jennifer Mee helped another person or persons commit or attempt to commit a crime, Jennifer Mee is a principal and must be treated as if she had done all the things the other person or persons did if 1, Jennifer Mee had a conscious intent that the robbery be done, and 2, Jennifer Mee did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually committed or attempted to commit the crime. To be a principal, Jennifer Mee does not have to be present when the crime is committed or attempted. In considering the evidence, you should consider the possibility that although the evidence may not convince you that Jennifer Mee committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if Jennifer Mee is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree is accessory after the fact, or I should say are, and manslaughter. Accessory after the fact. To prove the crime of accessory after the fact is included, the state must prove the following four elements beyond a reasonable doubt. 1, a murder in the first degree was committed by LaRon Rayford and or Lamont Newton. 2, after the murder in the first degree was committed, Jennifer Mee assisted, aided, or attempted to aid LaRon Rayford and or Lamont Newton. 3, at the time Jennifer Mee knew that LaRon Rayford and or Lamont Newton had committed the murder in the first degree. 4, Jennifer Mee did so with the intent that LaRon Rayford and/or Lamont Newton avoid or escape detection, arrest, trial, or punishment. It is not necessary for the state to prove that Jennifer Mee's assistance was successful in allowing LaRon Rayford and/or Lamont Newton to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that LaRon Rayford and/or Lamont Newton was convicted. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Manslaughter. To prove the crime of manslaughter as included, the state must prove the following 2 elements beyond a reasonable doubt. 1, Shannon Griffin is dead. 2, Jennifer Mee intentionally committed an act or acts that caused the death of Shannon Griffin. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was either justifiable or excusable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Plea of not guilty, reasonable doubt, and burden of proof. Jennifer Mee has entered a plea of not guilty. This means you must presume or believe Jennifer Mee is innocent. The presumption stays with Jennifer Mee as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome Jennifer Mee's presumption of innocence, the state has the burden of proving the crime with which Jennifer Mee is charged was committed, and Jennifer Mee is the person who committed the crime. Jennifer Mee is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find Jennifer Mee not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of Jennifer Mee may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find Jennifer Mee not guilty. If you have no reasonable doubt, you should find Jennifer Mee guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 9, has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? 10, does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature of quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Jennifer Me not testifying. The Constitution requires the state to prove its accusations against Jennifer Me. It is not necessary for Jennifer Me to disprove anything. Nor is Jennifer Me required to prove her innocence. It is up to the state to prove Jennifer Me's guilt by evidence. Jennifer Me exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his, really means her, decision. No juror should ever be concerned that Jennifer Me did or did not take the witness stand to give testimony in the case. Jennifer Me's statements. A statement claimed to have been made by Jennifer Me outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that Jennifer Me's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether when Jennifer Me made the statement she'd been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude Jennifer Me's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if Jennifer Me has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if Jennifer Me is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find Jennifer Me guilty as charged in the indictment, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to the crime charged. This verdict must be unanimous, that is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. It reads as follows. If you look up at me, I have the one and only one of these. All right, at the top is the name of the court and a series of numbers that mean a lot to us and absolutely nothing to you, which is perfectly fine. And then it says, State of Florida versus Jennifer Me, murder in the first degree. And then the verdict form reads, we, the jury, find as follows as to the defendant in this case. Very important, it says, check only one. A, the defendant is guilty of murder in the first degree as charged. So if you find that the state has proven the elements of murder in the first degree beyond a reasonable doubt, you mark A, check A. The foreperson signs the verdict form, prints his or her name, and dates the verdict form. If you find that the state has failed to prove murder in the first degree beyond a reasonable doubt, you then consider the one below it, B. And B reads, the defendant is guilty of accessory after the fact as included. If you find that the state has proven accessory after the fact beyond a reasonable doubt, you mark that. The foreperson again signs and dates the verdict form. If you find that the state has failed to prove accessory after the fact beyond a reasonable doubt, you then consider C. The defendant is guilty of manslaughter as included. If you find that the state has proven manslaughter beyond a reasonable doubt, you mark that, sign and date the verdict form. If you find that the state has failed to prove manslaughter beyond a reasonable doubt, you mark D, not guilty, sign and date the verdict form. So as I said in the instructions, you start at the top of the form. You see if that has been proven beyond a reasonable doubt. If it has, you mark it, you're done. If it hasn't been proven beyond a reasonable doubt, you consider the one below it. Has that been proven beyond a reasonable doubt? If yes, you mark that. If no, you consider the one below it, and so on down the form. Everybody understand? Okay. Now go back to the last page of your instructions, or second to last page. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. Your verdict finding Jennifer Me either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as of the jury as a whole. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Counsel, please approach the bench. Okay, since we have very wise bailiffs, I understand they had you pick your dinners some time ago. So since it's already after 6 and it's going to take about an hour to get it here, I assume you all would be happy for once you get back there and start deliberating to have the bailiffs order dinner. Am I correct? Yeah, okay, I see all your heads nod yes. Okay. Ms. Trahey, Ms. Cundy, Ms. Carlson, and Mr. Turner. You probably have to stand up to let the others by, but otherwise you may remain in the room, and the other jurors may go with the deputies to begin your deliberations. You'll be sent back with a tape player and all the evidence that was introduced. You may now take your notepads and pens. That very good question, yes. So you have separated out those ones that weren't admitted. And if you have any private property still in the back room, if you let the deputies know here, they will get it for you. So Deputy Birch will make sure we do that. Okay, great, great. So I need your pads and pens back. You can keep the instructions.
It's impossible to predict. It's like rolling dice. We'll just see when they come back. Hang in there. I know we got everything out.
Well, I'm sorry you can't deliberate. You all paid great attention throughout the trial. It is what it is. I'm sorry. Do you have the yellow Expando too? And I'll take care of getting rid of it. They've been here so long, they think they moved in.
Don't say that. Don't say that.
Yo.
Yeah.
Thanks. I'll shred those in the back. Thank you, ladies. Thank you. Okay, I think they're out, so you can take her back to the back. Does she have dinner back there?
She does.
Great.
we just have to, we can see. We can see the monitors.
Okay.
All right.
All rise. Court is adjourned till the call of the court for the verdict.